Frustrated viewers will be forgiven for thinking certain members of the Supreme Court of the United States, otherwise known as the SCOTUS, acted like children February 28th when the justices heard oral arguments over the so-called bump stock ban. The case is entitled Garland v. Cargill, and it not only hints that numerous members of the Supreme Court either can't or don't want to read the Constitution, it indicates that they also don't have a clue about how firearms work. It's a good thing they're protected by armed guards, whom we have to pay, even as these adult child judges ruminate and cogitate over our untouchable right to keep and bear arms. Hi everyone, I'm Gardner Goldsmith for MRC-TV, and SCOTUS blog's Amy Howe offers key background information to the case, which saw its genesis in 2017, when Donald Trump commanded the Bureau of Alcohol, Tobacco, Firearms, and Explosives, BATF or ATF, to categorize bump stocks as machine guns, ban their sale, and require owners to turn them in or destroy them, thus breaching not only the Constitution's prohibition against ex post facto laws, but also claiming executive branch power to ban something, and, more absurd than those dumb moves, also claiming that a gun part is a gun. And then to cap that off, flipping the proverbial bird at the Second Amendment once they had categorized the tool as a machine gun. In fact, some of the justices just saw fit to make things more absurd by not only focusing on the irrelevant and Kafkaesque question of whether a bump stock magically turns a single pole shot firearm into a machine gun, but by completely overlooking the key constitutional problems that so clearly are part of the ATF and are part of its bump stock ban. Notes how, quote, Michael Cargill, the owner of a gun store in Austin, Texas that is, surrendered several bump stocks he had in his store after ATF published its rule. He then went to court, seeking to have the rule invalidated. The full U.S. Court of Appeals for the Fifth Circuit ruled in Cargill's case that the definition of machine gun clearly does not apply to bump stocks. A machine gun, the Court of Appeals explained, is a gun that shoots multiple bullets automatically and by a single function of the trigger or any accessory that allows a gun to do so. But even if the definition were not clear, the Fifth Circuit continued, bump stocks should be excluded from the definition of machine gun under the rule of lenity, a doctrine that instructs courts to apply ambiguous criminal laws in the way that is most favorable to defendants. Howe notes that the Sixth Circuit Court of Appeals reached the same conclusion to a similar challenge in its region, but that the D.C. Circuit Court of Appeals found in favor of the ATF in a third similar case. No kidding, D.C. And so the big issue seemed to be this: did the ATF do wrong or right defining a bump stock as a machine gun? That seemed to be where they focused in the Supreme Court. Yeah, you'll be forgiven if you think you're looking at children playing make-believe. As I noted last year when the Supreme Court accepted this case, the question of whether a bump stock is a machine gun not only is patently obviously no, the question itself is completely irrelevant and is a distraction from the serious problems presented by the ATF activity. It also is a distraction from the problems presented by the existence of the ATF itself, and, of course, presented by the very immoral idea that any political forces can so-called forbid people from owning or buying something that unto itself brings no aggressive harm to any person or his property. Many of the Supreme Court bench overlooked the obvious in front of them, that there is no federal power to prohibit the purchase of any object, let alone a firearm, and that if a bump stock were to be categorized as a gun, it would get even more protection thanks to the Second Amendment. Instead, of course, they debated what the bump stock does and whether it turns a single shot, they errantly call that semi-automatic, whether it turns a single shot gun into a machine gun. As Sahib Itaba indicates for Barron's, that was where childish Justice Elena Kagan wanted to continue playing. Kagan expressed her belief that a bump stock allows multiple shots with a single human action, and that as a result, the 1934 Firearms Act allows the ATF to ban the bump stock. Even Neil Gorsuch focused on that question, though he disagreed with her conclusion. Quote, "It's a very old statute, and it was designed for an obvious problem in the 1930s and Al Capone," said Justice Neil Gorsuch. "Maybe they should have written something better," the conservative justice added. "One might hope they might write something better in the future, but that's the language we're stuck with." By focusing on whether the Firearms Act applies or doesn't apply to a piece of hardware, both of them miss the point. It would not matter if the 1934 statute were applicable. The statute itself is unconstitutional. One wonders which is more objectionable here, the fact that the judges like Kagan are so ignorant about guns, or the fact that even Gorsuch, a conservative, focuses on the 1934 Firearms Act to try to figure out if a bump stock can be considered a machine gun. First, let's set him and Kagan straight. A bump stock is an accessory. It's not a gun. Second, it doesn't turn any gun into a machine gun that fires multiple rounds with one trigger pull. It allows for faster trigger pulling by utilizing recoil to push the trigger back up against the firing finger. Third, even if it were a machine gun, or they wanted to pretend that it made a rifle a machine gun, the Trump executive order was not legislation. Fourth, if it were legislation, it would not be any more constitutional or moral to pass it or enforce the ban on a thing, the purchase of which not only doesn't harm someone, but also doesn't give any indication that it will be used for criminal purposes. Fifth, if they want to apply the 1934 Firearms Act to this, the act was not a ban on machine guns per se, because the feds can't ban items, especially guns. Because the Constitution allows for excise taxes on internal sales of goods, the 34 Act was a tax on machine guns, short-barreled shotguns, and silencers, the collection of which actually got the ball rolling for the official branch of the IRS called the BATF in 1952, which was originally purposed to be the gun tax collection muscle. If the feds wanted to try to fold bump stocks into the 1934 Firearms Act, they would have to apply the tax paradigm to the sale of the accessory, not outright ban it. If one really studies that FDR-era effort and then considers the universality of the Second Amendment, one must actually acknowledge that any federal excise tax or local or state tax on guns or ammunition is also a breach of the Second Amendment. Why? Well, since a tax is an imposition, i.e. a requirement by government to pay the government, or you can't exercise your right, it's an infringement on that right, placing a stipulation on how and at what tax threshold you can exercise your right. Those taxes are government infringements on your right to keep and bear arms. They make your right to keep and bear arms contingent on you paying a tax. Well, that is a clear infringement of the right. And if we can find a silver lining out of all this nonsense from the Supreme Court, well, these oral arguments about bump stock bans allow us to more clearly see that a tax on guns and ammunition is an infringement of the Second Amendment. Under any any strict scrutiny standards, such taxes would be held in contempt. But don't expect any of the confused Supreme Court judges to consider that or the other major problems tied to the ATF attack on our rights. Just its existence is a threat. Instead, they would rather waste time making up things about bump stocks, overlooking the fact that the ban completely breaches the Second Amendment, and of course the fact that it imposes punishment without trial and does so in an ex post facto fashion. Wow. All the things they miss. It is like watching kids playing and missing the real points about things. Wake up, Supreme Court. Wake up. Read the Constitution. Understand the logical application of the concept of rights. Thank you for watching, everybody. Please like and subscribe and spread the word about these bits of information contained in these videos. Thanks to the whole team at MRC-TV. You can find our videos uncensored at Rumble. And of course, we hope you'll follow us there. You can still find the videos on YouTube where, yes, they do censor us. Please double check that you are subscribed over there. You can find us all the time inside the Facebook page and check it out because it is very busy over there. You can find us on TikTok, on Instagram, and of course on Twitter/X. Please visit MRCTV.org and check out all the great items that the MRC-TV store has to offer, and consider donating to the Media Research Center. And of course, if you want to find me on Gab, I'm at Gardner Goldsmith, and on Twitter, I'm at Gard Goldsmith. For MRC-TV, thanks for watching. I'm Gardner Goldsmith.